Do you know what laws Trinidad and Tobago has to protect refugees?
Trinidad and Tobago signed on to the 1951 Convention relating to the status of refugees in November 2000, but has not yet drafted its own legislation to give effect to it. This does show, however, Trinidad and Tobago's intention to be bound by the provisions of the Convention. The Convention affords refugees in Trinidad and Tobago many rights, including the right to a family life, the right to an education for children, and the right to freedom of movement around the country. The Convention also seeks to protect refugees through the principles of non-discrimination, non-penalization, and non-refoulement. I will explain what these words mean in a moment. In Trinidad and Tobago, international law, like the 1951 Refugee Convention, can only be enforced if local legislation is enacted to give effect to the provisions of the Convention. As Trinidad and Tobago has never enacted any domestic legislation, this means that refugees in the country have very limited rights. They do not have the right to work to support their families, their children do not have the right to attend school, and they are not able to drive or to open bank accounts. They face discrimination and often feel very frustrated. Therefore, there is a need for local legislation to improve the lives of refugees in Trinidad and Tobago. This is what the Living Water Community and UNHCR are currently collaborating with the government on. It is important to remember that this can normally be a long process for any type of legislation.
Trinidad and Tobago has, however, implemented, with assistance from Living Water Community and UNHCR, to facilitate the asylum-seeking process. Asylum seekers firstly approach Living Water Community and are thereafter registered with UNHCR. UNHCR issues an asylum seeker certificate until their refugee status is determined.
Can you explain the main rights and principles under the 1951 Refugee Convention?
The right to family life in the Refugee Convention ensures that where a person has been granted asylum, his or her dependent relatives, that is, husband, wife, child, or civil partner, will also be able to receive protection through him or her in order to keep the family together. The country should also ensure that unaccompanied children are protected in relation to guardianship and care. The right to an education, as set out in the 1951 Refugee Convention and the Convention on the Rights of a Child, entitles children to a primary school education. Principles of protection of refugees are as follows. The principle of non-discrimination. This means that asylum seekers and refugees should not be discriminated upon as a result of their race, religion, or country of origin. This is set out in Article 3 of the 1951 Refugee Convention. The second principle is the principle of non-penalization. This prohibits countries from punishing an asylum seeker or refugee because of the way he might have entered the country. Some asylum seekers enter countries illegally by boat. They may also be dishonest to immigration or may overstay their time in the country. This should not be taken into account in determining whether a person will be granted refugee status, as this may have been the only way that they could have accessed safety. The only criteria that should be considered are those included in the 1951 Refugee Convention, that is, a well-founded fear of persecution and lack of state protection in the refugee's home country. The last principle is the principle of non-refoulement. This principle prohibits countries from sending an asylum seeker or refugee back to their country of origin or any other country where his life and freedom may be at risk. This is found in Article 33 of the 1951 Refugee Convention. The rights and principles set out in the 1951 Refugee Convention are therefore very crucial in protecting refugees.